Good morning, everyone. We will get started in 1 minute. We're doing a sound for the live stream.
Okay, good morning, everyone. I want to call to order the North Carolina Task Force for Racial Equity and Criminal Justice October 27th, 2023 Task Force meeting to order and say good morning and welcome. First, let me welcome our Chief Deputy General Counsel from the Department of Adult Correction, Mr. Nolan Graves. He's a newly appointed task force member from DAC and his first meeting with us this morning. So welcome, Chief Deputy General Counsel Graves. Look forward for your leadership and appreciate the partnership with DAC on this important endeavor for TREC. Without further ado, I'm going to turn it over to Justice Earls for the introduction of our fines and fees presenter this morning. Justice Earls.
Yes, good morning. Thank you, Secretary Buffalo, and thank you to everyone who's joined us this morning. I'm really excited about this meeting. We're going to hear some great presentations and I think get inspired for some work that we have in the future. But I'm also really thrilled to hear from the committees because I know there's been a lot going on, and just to get the update of the work that's been happening. So thank you all for being with us this morning. I am especially excited to introduce to all of you Annie Hudson Price. And if you'd like, let us wait. There you go. She is incredible, and so I just want to tell you about her background. She is currently senior counsel at the U.S. Department of Justice Office for Access to Justice, and she focuses there on criminal justice policy, including the intersection of economic justice and our criminal legal systems. So right in our wheelhouse of exactly the kind of expertise that we need. Before joining the Access to Justice office, she worked for 10 years as a civil rights attorney, bringing impact litigation throughout the country to advance social, economic, and racial justice. She began her legal career as an Equal Justice Works Fellow, advocating for alternative sentencing on behalf of justice-involved veterans and foster youth. She went on to become a core member of Public Counsel's nationally recognized Opportunity Under Law project. And in that project, she worked with impacted communities to bring precedent-setting litigation on behalf of underserved students, DACA recipients, and injured workers. Most recently, she served supervising litigation at the Policing Project at NYU School of Law, and there she led the organization's attorneys' litigation efforts challenging discriminatory police practices and the unconstitutional use of surveillance technologies. So she's a graduate from Yale College and Harvard Law School, and she has graciously agreed to join us today to give us a sense of some of the work that's going on around the country on fines and fees, and to engage with us in a discussion. I've had the chance to give her a little bit of background on what our task force has been up to and what's been happening in North Carolina. So we're really hopeful you all will have questions and we can engage in a dialogue. So Annie, thank you so much for being here with us this morning, and I'll hand it over to you.
Thank you so much, Justice Earls. That was an incredibly generous introduction, and I'm sure more information than anyone needed to know about me. But I really appreciate it. I'm so excited to be here this morning. This is the work you all do is so important and amazing. And Justice Earls sent me the report from, I believe it was 2020. It's just incredible, the work and effort that you all have put into this important work. So as Justice Earls said, my name is Annie Hudson Price, and I'm senior counsel on the criminal policy team at the Office for Access to Justice. For those of you who are unfamiliar with the office, it's a standalone agency within DOJ, the federal DOJ, that plans, develops, and coordinates the implementation of access to justice policy initiatives of high priority to the department and the executive branch. And to put it broadly, our mission is to ensure that all communities have access to the promises and protections of our laws. And we work towards this goal by fighting to break down barriers to the founding principle of our legal system, equal justice under law. So as Justice Earls mentioned, I've been invited to speak about our work related to criminal legal system fines and fees, and to provide some concrete examples of what various jurisdictions are doing around the country to address some of the unintended harms of fines and fees. But I know already that this is an area with which many of you are deeply familiar. The 2020 report had the incredibly thorough and moving section on fines and fees. So I hope the examples I share today won't be too repetitive. I hope it can actually just help advance the conversation and the incredible work you're already doing in this field. So before I turn to sort of the work DOJ is doing and some of the concrete examples, I wanted to take a moment. Again, information you're probably all familiar with, but to sort of recenter the human impact of fines and fees, especially when they're assessed without consideration for an individual's ability to pay. While a $500 fine or $200 in fees may be an inconvenience if you're an affluent person, if you're low income, it can mean choosing between paying the fine or fee or feeding your children and paying rent. And if you fail to pay the fine or fee, the ramifications, both direct and indirect, can escalate incredibly quickly. Individuals who are unable to pay court-assessed fines and fees, depending on the jurisdiction, can face snowballing financial penalties, late payments, interest, collection consequences, extended justice system involvement, suspended driver's license, unnecessary incarceration. And then the indirect consequences, of course, can be just as devastating, including loss of housing, loss of employment, loss of voting rights. And, to put that more concretely, when the issue that first brought me as a young attorney to care deeply about this issue is one of my first clients. As Justice Earls mentioned, I worked with foster youth, and one of my first clients was a young father and former foster youth who came to a clinic I ran, and he had lost his driver's license for failing to pay a turnstile hopping fine from when he was 17. He's now 25, he's no driver's license, and that initial fine is thousands of dollars in late payments and penalties. And he also now is, at 25, has a 2-year-old daughter who he's deeply committed to. And she has been diagnosed with an operable brain tumor, but he does not have health insurance at work, and it's an incredibly expensive operation. So he goes to his manager, shares the situation. His manager says, I really want to help you. The only jobs in our company that come with health insurance are the driving jobs. And so he goes to the court and says, please, I need my license reinstated. I'll do anything. And they say, well, you can pay the $4,500 in fees right now. We can reinstate it. Or you can schedule a hearing. The next hearing's in 13 months. And as you can imagine, his daughter didn't have 13 months. So he came to the clinic. I, baby lawyer, had no experience. This is the most useful I've ever felt as an attorney, but we went into the court. It turns out if you have a lawyer, you can see the judge the same day, which, it's a little, can be a little frustrating because often the people who can afford a lawyer are also people that can afford to pay the underlying fines and fees. But, long story short, we are able to get him in that same day. We resolve the issue and he gets his license reinstated. But that for me was the first time I'd really understood. And obviously no one in the system wanted that outcome. No one wanted this young man to not be able to get a job that would help his daughter survive. So it was the first time I'd really gotten a glimpse at some of the unintended consequences and what can happen when policymakers are divorced from the consequences and the actual real impact on impacted communities. So what is DOJ doing about fines and fees? What are other jurisdictions doing across the country? So to start with DOJ, as many of you, I believe, are aware, in April of this year, the Office for Access to Justice joined the Civil Rights Division and the Office for Justice Programs in issuing a Dear Colleague letter to state, local, and juvenile courts regarding the imposition and enforcement of fines and fees. The letter sort of provided sort of a legal overview and cautioned against the assessment of legal fines and fees, which may be unlawful, racially discriminatory, or may unfairly penalize individuals who are unable to pay. And we hope that letter itself, the existence of the letter, can be a useful tool, but we also hope that the contents of the letter, so for the defense bar, for judges, for prosecutors who are trying to understand the legal landscape, that just the content of the letter can serve as a useful tool to stakeholders in this area. That letter also previewed that our office, ATJ, would be issuing a follow-up report, expanding upon the principles in the letter and highlighting some of the most common and most innovative fines and fees approaches from across the country, along with concrete examples of implementation at various levels of government. So I think that's why I was invited to speak today. We hope that report will be released in the next week or two. And that report will summarize some of the most effective and, as I mentioned, innovative fines and fees approaches from across the country. We hope it will serve as a resource for policymakers. And we also hope, the list, it will feature a number of concrete examples, many more than I'll go over today. But so I thought it would be helpful to just highlight some of the highest level what we're seeing from across the country, categories of reform, and then also some of the concrete examples. So I'll start by focusing on the exciting things happening in North Carolina. I understand that this task force was instrumental in the recent administrative rule change by the North Carolina Supreme Court that allowed judges to even conduct ability to pay hearings prior to assessing fines and fees. That alone is, that's sort of the foundational work that needs to be done before any of this other work can happen. So congratulations, that's a crucial step that really warrants celebration. North Carolina is also one of only 6 states that fully funds its victim services through appropriations and not through revenue generated by fines and fees. North Carolina has some of the clearest language ensuring that individuals who are acquitted or whose cases are dismissed do not have to pay fines and fees related to that case. This includes not only court fees, but fees like the pay to stay or room and board fees that are often assessed against defendants when they're detained pretrial. That is not the case in every state. In some states, individuals can still owe fines and fees even if they're acquitted or the case is dismissed. And in 2020, the North Carolina legislature passed a law that did authorize individuals whose licenses were suspended solely for failure to pay to apply for restricted licenses. Finally, in the city of Durham, is everyone familiar with the DEAR program in Durham? So I won't belabor it, but my understanding is it's a pretty exceptional program. You actually have collaboration between the courts, the DA, the public defender, local law schools, local nonprofit and advocacy groups. It's the North Carolina Equal Access to Justice Commission it's the Durham Expunction and Restoration Program. And like I said, many of you probably know this better than I do, but amongst other services, it allows residents to address the consequences of unpaid fines and fees, supporting driver's license restoration by waiving tickets and old criminal charges, assisting applying for restoration of driving privileges, and working to establish regular streamlined ability to pay processes and providing training and technical support on the local ability to pay forms. So other jurisdictions have tackled fines and fees from many different angles and at all levels of government, local courts and DAs, all the way up to state legislatures. And the examples I provide are chosen somewhat at random. I don't mean to be favoring certain states. These are just, I think, clear examples of some of these categories of reform. And I should say, obviously, some states will take like a sweeping legislative approach. Others are approaching more incrementally. And both can be incredibly powerful depending on what's realistic in a certain state and how things operate local versus statewide. So to start with, states that have eliminated whole categories of fines and fees, oftentimes this legislation will focus on like a category. So juvenile fines and fees is seems to be a common first step in a lot of states. So for example, New Mexico is one of several states that has just eliminated all fines and fees in the juvenile system and forgiven all outstanding debt associated with it. And to give you a sense of how this can happen at different levels, we've also seen in Dane County, Wisconsin, the Board of Supervisors voted to eliminate all local juvenile fines and fees. In New Orleans, the chief judge of the Orleans Parish Juvenile Court signed a resolution stating that the court would no longer assess or collect juvenile administrative fees. And then in Hawaii, in Kauai, the prosecuting attorney for the county issued a memo stating that her office would no longer seek to impose discretionary fines and fees and would object if the court or any other party sought to impose them. So you can really see how this can happen in various offices and at various levels. Other jurisdictions have focused on eliminating, diversion program fees or probation fees, parole fees, just to name a few examples of how you can go by category. Other states have focused on alternatives to fines. So, for example, providing community service instead. And Texas is actually a really strong example here because they allow courts, they authorize courts to have indigent defendants discharge their fines and fees related debt through community service, but they define community service to include work or job skills training programs, educational programs, alcohol or drug abuse programs, rehabilitation programs, mentoring programs, and even working for like a nonprofit or an educational institution. And that's not an extensive, an exclusive list. Another important category of addressing fines and fees has been jurisdictions that are focusing on meaningful and reliable ability to pay determinations. So bench cards have become an effective tool from the judiciary to provide judges with guidance when issuing ability to pay hearings. But a number of states have also codified presumptions of indigency. So it sort of takes the burden off the judge. It ensures uniformity and prevents courts from assessing fines and fees against a defendant that will never be able to pay in the first place. So Oklahoma just this year established a presumption of indigency, of inability to pay for defendants who are designated disabled by any government disability program, who receive they have a list of public benefits such as food stamps or Social Security. If you receive those, there's a presumption that you cannot pay. If they receive a government housing subsidy, and then they're sort of the baseline or if they earn below 150% of the federal poverty level. California has taken another step. They've introduced an online tool called My Citations, and they developed this tool using a free platform. I forget what platform it was, but essentially it's usable on mobile phones, and it only applies to citations, but a user can go to the website. They don't need to create a login. It's designed to be as user-friendly as possible. You just click through, and you can, through your phone, request that a judge either reduce a citation, give you more time to make a payment, authorize a payment plan, authorize community service in lieu, and it gives you the chance to upload benefits and to upload proof that you're on benefits, to list all expenses you have. So you can say, I have this outstanding medical debt for a family member that makes it impossible for me to pay this. And then on the judge's side, the program is also very user-friendly, where the judge can sort. Clerks they establish internal rules where clerks can just quickly go through the requests and they know what the internal policies are. So those are some examples in the ability to pay world. And other jurisdictions have focused on flexible payment options to make it as easy as possible for indigent defendants to pay. So Florida recently passed a statute where indigent litigants are able to enter into monthly payment plans, and they set a limit on the payment plans. So the payment plan rate can be no higher than either 2% of the individual's annual income divided by 12 or $25, whichever is greater. So it prevents, sometimes there are payment plans, but if it's a $1,000 ticket and you owe $300 in 3 payments, then that can be very difficult. That can be just as impossible as not having a payment plan in the first place. And the law also caps the down payment requirement at 10% of what the individual owes, or $100, whichever is less. And then even to give an example of a sort of even more simple step that can be taken, Houston municipal courts allow individuals to pay fines by mail, online, in person, Western Union, by check, by money order, by credit card. So just ensuring that folks who are trying to pay are actually given the opportunity and aren't experiencing the consequences of not paying, even though they're trying. So then there's also the enforcement side. So as I'm sure folks on this call are aware, it's unconstitutional to incarcerate someone for their inability to pay a fine or fee. But what often happens is that the defendants who are unable to pay still get incarcerated for failure to appear. So in other words, they know they're unable to pay. They don't attend the court date because they think nothing's gonna be able to happen at that court date because they're not gonna be able to pay. And now they've got an outstanding warrant for failure to appear. Or like a traffic ticket, you know, if we get a traffic ticket, you can just pay it online. But if you can't pay it, that's technically, you're not appearing, you're not entering the payment, and you're not requesting a court date to say, I can't pay this. So despite it being unconstitutional to incarcerate folks for inability to pay, they're still getting incarcerated for failure to pay without that determination being made. So some states have taken steps to address this and to ensure that that's not happening unintentionally. Florida has addressed this issue with legislation that prevents courts from ordering someone to be incarcerated for failure to appear unless the underlying charge authorizes incarceration. So if it's just failure to pay a traffic ticket, you're not going to be incarcerated for that. Missouri similarly prohibits incarceration for failure to pay if it's a minor traffic or municipal code violation, regardless, without an ability to pay determination. And sort of the last category I'll talk about with enforcement is lifting debt-based driving restrictions. There's been a lot of movement in this space in the last 5 years. I think 25 to 30 jurisdictions have, at the state level, have taken steps to relieve some of the unintended consequences of linking driver's license suspensions and registration suspensions with unpaid court debt. North Carolina, obviously, being one of them that has taken steps in this direction. And you know, things like restricted licenses, like as are allowed in North Carolina, can prevent indigent defendants from having to choose between getting another conviction for driving on a suspended license and going to work, school, medical appointments, caring for family members. Some states have done away entirely with debt-based restrictions, but I think North Carolina has taken the step of at least allowing drivers to be able to go about the necessities of life. So Justice Earls also asked me to talk briefly about, these are all legislative changes, but what can happen, task forces, what are folks doing around the country that aren't necessarily at the policy making, the legislative level? And so I wanted to say briefly, task forces like this one across the country, one of the major contributions I think that are being made is data collection and institutional transparency. So it is impossible to take meaningful steps towards reducing reliance on fines and fees and addressing the harms without first understanding what is actually happening in a given jurisdiction. So there is an acute need for data to inform policymaking. What fines and fees are actually being assessed? We've spoken to jurisdictions where there have been so many incremental fines, so many incremental fees added to the list that since the 80s, that legislatures, judges don't even know how many fees are automatically added on because there's the $1 crime fighting fee, there's the $1 administrative fee, and it actually adds up to an incredible amount. So even having a sense of what are all the fees that individual defendant might face and what does that add up to? What percentage of assessments end up in collections? So oftentimes when you hear quotes about how much a jurisdiction is collecting in fines and fees, you're not actually hearing how much is collected, you're hearing how much is assessed. And so having a sense of what percentage of the amount that is assessed is actually going towards the jurisdiction. And what percentage is never collected? How much is a jurisdiction spending on collections? Which can make that total amount a lot lower. What are specific fines and fees actually funding within a jurisdiction? I think it's South Dakota issued a really interesting, for transparency purposes, they broke down what a traffic ticket, what every single component of a traffic ticket, what each of those fees goes towards. So here's the $2 education fee, here's the $4, police training fee. And so you can really see what each aspect of that fee is going towards, of the total ticket is going towards. And that can help a jurisdiction figure out what fees we're willing to start to look at getting rid of, which ones of these are funding necessary services that we need to find alternatives for through appropriations. And so, until a jurisdiction has answers to these questions, it can be very difficult to take meaningful steps. And in the similar category, other task forces have worked to create opportunities for impacted individuals to meet with policymakers. So it's another form of ensuring that the important information is getting to the policymakers to ensure that they have the chance to understand the unintended consequences. And we've heard stories about how impactful these conversations can be. And lastly, I think that the Dear Colleague letter encourages jurisdictions to provide appropriate training for judges, prosecutors, and probation officials regarding fines and fees. And it can be hard to figure out where that onus falls, where those trainings can be created. I would add defense bar to important training opportunities, and detailed benchmarks, as I mentioned before, can be an invaluable tool. So these are only some of the approaches taking place across the country. I have dumped a lot of information onto you. I hope this gives you like a good sense of the sort of variety of approaches, and how many levels of government it can happen, how varied the levels of government the policy changes can take place. And thank you, Justice Earls, again. I'm so grateful for the opportunity to speak with you all. And I look forward to sharing the final fines and fees report when it's published. It will have a lot of this information and more. And just in general, ATJ is so grateful for the opportunity to work alongside folks like this team. And we look forward to continued opportunities to support your work.
So now we have opportunity for questions, and I see one hand up already. So just so you know, would you all tell our guest who you are and then ask your question? But I'll call on first our District Attorney, Jeffrey Neiman.
Thank you, Madam Justice. Yeah, so I'm Jeff Neiman. I'm the, excuse me, the District Attorney in District 18, which is Orange and Chatham counties. I will say I'm pretty proud of the robust license and expunction restoration council that we have in Orange County. We're hoping to expand that to Chatham County soon. And the issue of tying license and driving privilege to court debt is an issue that has been, I guess, a side passion of mine for 15 years now, and definitely want to make clear I come from a place of being fully supportive of the effort you're talking about and everything when I ask this question. But so my understanding, and this goes back to even before my time, is that what used to happen historically, if somebody didn't pay a traffic ticket debt, that the remedy was that an order for their arrest was issued, they were arrested, pulled into court, and then either they serve some time to pay off their debt, which is kind of like a debtor's prison, and that's bad. And also it was onerous on law enforcement because it ballooned the number of arrests that they needed to serve. And so that was when they changed the system to, well, we'll just block their license, right? And that will be a way to compel someone to come in and pay their fines. My question is, notwithstanding the fact that I completely agree that judges should be making assessment on ability to pay when they assess fines, if we don't arrest them, which I don't think is a good idea, and we're getting away from, and we move away from suspending their license, what of these other states or what ideas have been proposed for having some way to compel people to pay court fees at all? Like, let's assume we're talking about people who can pay. What is the mechanism?
I think it's a great question, and I think, I think, I hate to I don't mean to dodge it. I'm going to start with the flip side and then come back to, I think, the mechanisms that are being used. I think the flip side is, I think the bigger thing is jurisdictions are looking at, is it better to have a method of compulsion that actually hurts us more than it helps us? Because it's very difficult to pay off a ticket if you don't have a driver's license and can't go to work, and now we're facing unemployment. Another story I didn't tell was, I just heard recently someone when they were 17 lost their driver's license. When he was 17, had a court fee, finds out at 25 that he didn't pay it, driver's license suspended. He loses his job because he drove for work, and he actually loses his apartment and becomes homeless. So that is certainly not going to get anyone. So I think, and like you said, it actually costs quite a lot to incarcerate folks, and it is a huge burden on law enforcement to have to make these arrests and these stops for failure to pay. So I think a lot of the calculus is this doing more harm than good? I think the question of how do you compel, I think part of that is ensuring there are meaningful ability to pay hearings so that you can identify which folks are able to pay. Some jurisdictions have engaged in wage garnishment. Some have found other, I do think the penalties, adding additional penalties, but I think, wage garnishment shouldn't happen until there's already an ability to pay hearing. So I think that is a necessary first step, but then there are, tax refunds are held. I think there are other mechanisms, but I think the first question is this helping our cause of actually collecting meaningful fees?
For me, I think we're
Which-
past
yeah.
that. Like,
Yeah.
I think it's not a great system. I
Yeah.
as someone who wants to advocate for not
Yeah.
attaching license privilege to court debt, I want to be able to give people some alternative solution,
Yeah.
as opposed to the wealthy person who says, I got a ticket. Well, come
No,
get
it's truly a hard question. I think another big thing that jurisdictions have done are having sort of like amnesty days where they say, all right, you won't be arrested for not paying your fees. Come in now. The court will work with you to figure out what of this percentage can you pay, and let's get this off your back, because that has proven to be incredibly effective. So you have local jurisdictions who work with the court to host an amnesty day. Folks come in and you see and you sort of do on the spot ability to pay hearings to sort of eliminate as much debt as possible. And often what ends up happening is the judge and the individual come to an agreement. Okay, I can pay 200 of this 1,500. And that's 200 that the court would have never gotten, the jurisdiction would have never gotten. And it also relieves the individual of all this, the burden of the outstanding debt and the stress of it. So I think that's a step jurisdictions can take to sort of at least figure out what can be recouped. But I think the real challenge is in a lot of these situations, folks just can't afford to pay it, and they're too afraid to approach the court to figure that out because they don't understand that they may have the rights to negotiate that. But again, I don't think I have an incredibly easy answer. I think a lot of the work in this area is saying we need to look at fines and fees in general and whether or not it is, appropriate to shift the tax burden onto. I think fines is a separate question, but for fees, I think a lot of the work is looking at, is this an effective way to fund government?
I'm definitely with you on that. The ballooning costs and fees is crazy. I just do think that some percentage of people who get tickets, I'm talking about the guy who's driving the Ferrari,
Yeah.
who gets, that guy should probably pay his fines and fees for a speeding ticket. And I just want to have a good
Yeah.
solution to collect that.
I think 100%. And I think there are collections options that if you have the meaningful ability to pay opportunity, then things like wage garnishment or withholding taxes. I think the challenge, of course, is that if you don't do that right, then you'll start garnishing wages from folks who need those wages in order to feed their families.
What other questions do people have? So I'll just, we have just a couple more minutes and I just want to follow up a little bit on, so I'm thrilled to look forward to your report and a lot of what, and that we'll get even more details about what you've told us about. It's been incredibly helpful to hear kind of the different categories of approaches, but I'm still thinking about like so you've seen our recommendations, you kind of heard what we've done so far. It sounds like you're suggesting that data collection and answering some of these data questions would be a good next step for our commission to be thinking about. And so then I'm like, so what can DOJ do to help us?
That's a great question. I know the Bureau of the BGA, the grant funding arm there has been some grant funding around fines and fees. That's not our wing. But I also know, if ATJ is here to be a partner in this work. So to the extent we can help think through categories of data collection, who partners can be, ways this can happen, we'd be thrilled to continue the conversation. There are lots of organizations that have, even more expertise than I do, that have been doing this work on the ground, that I'm sure would be thrilled to support it. So I'd be thrilled to continue the conversation and figure out ways that HEJ can support your work. I know CRT, the Civil Rights Division, is also wants to be an ally in this work. So I think it's more serving as a technical resource guide, an ally in this, and there may be more concrete steps. I'm embarrassed to say I'm not sure what the technical assistance grants were focused on, but I know those are out there as well.
And so that's great to hear, and that is a huge help. And I sort of feel like now you know about us. If you see of opportunities to connect us with other folks that can help with some of this work, please do that.
Absolutely.
But then the other thought I had was, I do think, especially at the local level, if there's advocacy that we can do there, and in some way just create the climate for better understanding of the issue. Is your office working on ways, for example, to either collect individual stories or tell those stories? Do you have any efforts in that arena?
That's a great question. And, this report is coming out shortly, and then I think we'll start thinking about, for our office, what next steps are. But I think collecting individual stories is a hugely important part of this process. And it's often what leads to change at the policy level, is sharing individual stories, making real the impact. So that's a great suggestion, and something that we'd be really thrilled to partner with and think through and how we can support that. I also think at the local level, we'd be happy to try to help facilitate connections across jurisdictions where you are seeing this at the local level, that, if there is a local DA that we think would be willing to speak, who has implemented some changes, that maybe there are partnerships that can happen to lessons learned around changes that have been made at various levels.
Well, and before we leave this topic, I sort of want to put our task force members a little bit on the spot, but you talked about some of the incremental but nevertheless important legislative changes made in states like Florida and Texas. And so I'm just wondering if there's any of our if there was anything that task force members want to highlight as, are there possibilities in that regard in North Carolina? And if so, are there ways we should think about how to go about that? Like, I don't want to just ignore the possibility of legislative change.
Justice Earl, Billy Gardner. Can you hear me?
I'm sorry, I couldn't tell who's trying to speak.
It looks like it's Billy Garden. It's breaking up a tiny bit, but now it looks like it's good.
Okay.
Yeah. I was really interested in the option for community service, and if North Carolina is moving in that direction, and if not, then how do we get the ball rolling? And I feel like an option for community service seems that it would better serve the community as well as the offender in trying to get some of these fines taken care of. As a police officer, you stop a number of people who don't have a license, and you run their history, and you see that this is an ongoing issue, and immediately it's for failure to pay some kind of fine or something. It just seems very counterproductive to suspend somebody's license because they didn't pay a fine on a ticket. Seems that it would be common sense that if you remove their ability to drive to work, then they're probably not going to be able to pay this fine. So I like the option of community service, and it seems to me that would be maybe a lot cheaper to recoup community service than it would be to try to go after folks for not paying fines. So I'm just wondering how we get the ball started on that, if you're aware of another state that actually forces the community service option.
Did everyone hear the question there, which is sort of if we were to think about community service as a way of essentially paying your fines, like how did that get underway? Do you know, like how?
I'm not sure what the very initial step was, but I believe there was a similar task force led by Chief Justice Hecht in Texas, and I think they were instrumental in some of the movement that was made in Texas, including around. I mean, I think the important thing is an expanded definition of community service that they did in Texas that can really, as Mr. Garten pointed out, that can actually help the community, which is, having rehab be considered a form of community service, rather than it just being sort of like a pro forma, picking up trash off the side of the road, which itself can be a real service to the community, but actually doing versions of community service that can have a rehabilitative component, including, workforce development. That's another thing that we've seen in jurisdictions, having to go to job trainings and skills building classes.
Great. Well, we have imposed on you, I think maybe slightly beyond our 30 minutes. Does anyone else have any questions or reactions or comments they want to make at this point? Yes, Kerwin, go ahead. And please introduce yourself.
Yes, my name is Kerwin Pittman, but I think Emily was first. I want to yield.
Oh, I'm sorry. I did not see that.
Emily, are you able to go? Now I can jump in with this, and I really just had a statement.
Okay.
And hello, my name is Kerwin Pittman, social justice activist, advocate. And I just wanted to add that North Carolina does have a fines and fees coalition that is a part of a larger fines and fees coalition. And I know that the North Carolina coalition is engaged with legislative stakeholders quite regularly. So it may be good to kind of pull them into this conversation, Justice Earls, and kind of see how they'll be able to help and kind of their views, points, and kind of, because they have a greater view of the landscape of North Carolina, so to speak, when it comes to fines and fees, but also connect them with you as well, Alice. So, but thank you for your presentation. It was extremely helpful and great. And however I can assist you in the fight, definitely feel free to reach out.
Yeah. Thank you. And that's a great suggestion. I appreciate that. Any other comments or ideas or questions? So Emily says she's in the chat. Her question is whether the report will be accompanied by a training webinar, because that would be very helpful.
That's a great question and a great suggestion. And I will bring that back to my team.
Well, we have given you your marching orders, but seriously, unless anyone else has comments, I'm going to thank you and let you get on with the rest of your Friday. But this has been enormously helpful, and I really appreciate the time you've given us and these great ideas.
Thank you all so much. And I know it was a lot of information. I appreciate everyone. It's a lot of information for Friday morning. So I appreciate everyone bearing with me, and thank you so much for the opportunity.
Right. Thank you.
Right.
So our next presentation, I was all ready to introduce Attorney John Powell, but apparently there's some technical issues. So we are turning to Kim Banco to do the restorative justice presentation. So Kim, I'm sorry I can't tell folks more about your background, but please go ahead.
Okay, can you hear me?
Now we can, yes, thank you.
Okay. Good morning. Thank you for letting us be here today. I have been with the Department of Correction, DPS, for almost 28 years, and currently the Director of Victim Services for the Department of Adult Correction. And so I think John and Holly were supposed to give a brief presentation about the the Victim Offender Dialogue Program that Hollywood, excuse me,
Thank you.
that Holly was involved in back in May. So really, I was just going to do a little short introduction for, and then let them take over. So back, how this whole thing started was back in January of 2021. My office got a call from the warden at Orange Correctional saying that she had a victim that it called her, and that was going to come visit an inmate the next week, and she wanted to know what she needed to do. And so she gave me the information and what the call was about, and then I reached out to the victim, and then that started the whole process of the historical VOD that took place at Orange Correctional back on May 16th. To be brief, after speaking with the victim at length and knowing that there was not an offender dialogue program in place, I reached out to my leadership for approval to move forward with it and to contact John Powell with the Campbell Law School Restorative Justice Clinic. And I knew John from years back, and I knew John could help me with this endeavor. And he said yes immediately. And then that is when the journey began. So I will just turn this over to Mr. Powell and Ms. Gilmore for the presentation. Thank you.
Hey, folks, you got some amazing tech people. I felt like I was trying to land an airplane with no lessons a while ago, but they got me here. Glad to be on the ground. What an honor it is to be speaking with you, to be able to do this work, to have the doors of the prison opened so that we could make this event happen for Holly and for Jimmy, and hopefully for future victims and offenders in the state of North Carolina. I know that we do have limited time. We want to use that wisely. So I normally talk a long time, but I'm going to stop talking and I'm going to hand this over to Holly Gilmore so you can hear from her.
Hi, and good morning, everyone. And thank you so much for having me. It truly is an honor to be here in front of you to discuss a little bit about my journey through this restorative justice process and through the victim offender dialogue. As was mentioned a moment ago, I am the victim in the Jimmy Jones case. In 1990, he broke into my apartment. I was a senior at the University of North Carolina, Chapel Hill. And I was brutally attacked and raped, and he was ultimately convicted at trial. Fast forward 30 years, and it was September of 2020. I was working from home because of COVID, and I received a phone call from the Honorable Jeff Neiman, who is now the elected DA for Orange and Chatham County. I believe he's on this meeting this morning as well. And he had indicated to me on that phone call that Jimmy Jones had befriended a retired Superior Court, Orange County Superior Court Judge, Judge Devine, and she was acting as an advocate per se for him. And she was interested in perhaps hearing my side of the story, or how I was doing, or how I felt about Jimmy being released. Her ultimate goal to this day is to have him released after he has spent 30 years in prison on a life sentence, which he received for the crime he committed. And I very eagerly volunteered to speak with her. Jeff arranged those phone calls, and that began a 3-year journey that has been amazing. It has touched my heart. It has changed me as a person. It has brought me strength and courage. I've made friends that I consider my family. We started a weekly meeting towards this goal. And it was Jeff Neiman, myself, and Judge Devine. During those meetings, I very quickly learned that Jimmy had gone through a 20-week program in the prison called SOAR. And the more I learned about that program, I wasn't very impressed. I became rather offended when I was shown a picture of a chair. It was called a victim's chair. And it had the words painted on it: shame, disgust, embarrassment, pity, all these horrible words. And Jimmy was supposed to speak to that chair and as part of this therapy program, and assume that the victim was sitting in that chair. And during this therapy program, he was able to tell his victim, quote unquote, what he wanted to say. And I became rather upset at that, because I felt like no victim should ever be represented by an empty chair. Empty chairs are used for people who are who are deceased. We use an empty chair at a wedding. We use an empty chair at our Thanksgiving table when our relatives are no longer with us. And so at that point, I stood up without really thinking about it. And I said, no, this isn't right. And I'm going to go back and sit in that empty chair. And if he has something to say, he can say it to me without these horrible words painted on this chair. This is not something that I wanted to do. This is not something that I had planned to do. Before this journey started, I never wanted to see him again. But as we went through this entire process, it became so empowering and so life-changing for me. We went through years of these meetings in preparation. Jimmy had to agree to the meetings. And the day of the meeting, once I walked in there, it was probably the most difficult day of my life. But I felt surrounded by support, both through the prison, both through my advocates. My best friend was present with me, as she had been through all of the meetings as well. I felt a tremendous amount of excitement, if you will, for a lack of a better word, that this could be life-changing, not only for me, but for other victims. And as I sat down at that table, I was less than a foot away from the man who I had never seen. Well, I hadn't seen in 30 years. The last time I saw him, he was attacking me on the floor of my apartment. And I had no idea who he was at the time of the crime. I was scared to death on May 16th when I walked into that meeting. But with the help from Kim Benko and Jeff Neiman and John Powell, I felt so strong. And I sat there for 7 hours. And I brought with me 9 pages of questions that I had for Jimmy Jones. They were questions about just anything. That information was important to me. I wanted to know what he did the day of the crime. I wanted to know why he was out of custody for 4 years pending trial. There were just a whole bunch of questions. I wanted information. And through that 7-hour process, that meeting, there were a lot of tears. There was a lot of questions, and I did get a lot of answers. And I walked out of there feeling like a different person. Jimmy had asked me in the beginning of the meeting, as we went around and we talked about what we wanted our goals for the meeting to be. Jimmy had said, I want Holly to see my humanity. And that really touched me in a way that I hadn't even thought of before, because he had always been a monster to me, this horrible person who had offended me in so many ways and who had hurt me. And I didn't really think of him as human until that moment when he asked me to see his humanity. And I did. I looked at him as a human. And as the meeting went on, my tone towards him softened a little bit. And it just became a very, very special moment for me. I wouldn't say in my healing, after 30 years of counseling and treatment that I've been through, it wasn't a matter of healing. It wasn't a matter of closure. There's never closure to a violent crime. There's never closure for a victim or a survivor of a violent crime. But the way I look at it is it's a new beginning for me, a new way to look at things. And I really hope that this program can be opened up and it can be an opportunity for other victims of violent crimes. I think it's so important that it be victim driven, because so many times victims they are stripped of their power, they're stripped of their individuality when these crimes occur, and allowing the victim to have some control over this victim offender dialogue. Control meaning I was allowed to walk into the meeting first, or not first, but I was allowed to walk into the meeting. I was allowed to have these meetings beforehand to kind of prepare for the big meeting at the prison. I also think that these meetings are vital, that they occur at the prison with the protection, with law enforcement protection that was there. There was a sergeant there, a corrections officer who was there. And I just think that it makes all the difference in the world. You could try to have a meeting via Zoom or electronically, but it just wouldn't be the same. It wouldn't be as powerful or as meaningful. Having the meeting there at the prison with the proper preparation is vital in this program. I don't want to take up too much time because I want to give it back to John Powell, but I want to say thank you so much. And if anybody has any questions at any time, I'm always love to hear from all of you. So at this point, I'll give it back to John Powell to follow up. Thank you very much.
Thanks, Holly. And we do just want to give time for any questions, anything that we can answer, comments at all from anybody.
I'm not seeing any hands. I apologize, especially if folks who are not on video are trying to speak. You don't need to wait for me to call on you. You can just, oh, thank you, Representative Morey. Go ahead.
Yeah, thanks so much. And Holly, that was very powerful. And what a journey. Going through what you've gone through, does that change your outlook about the offender's rehabilitation, the possibility, I guess you've said it was almost 30 years of him having paid his debt, remorse, you've seen him as a human for him to be released, or was that not the purpose of the meeting?
I'll give you, I think there's two answers to that question. His release was not the purpose of the meeting. The purpose of the meeting was for the victim, was for me, to have my questions answered and ultimately to sit in that empty chair. That was so important for me to do. However, during the process of that meeting, obviously, you know, he is up for parole. He received a life sentence plus, I think it was plus 20 years. His life sentence was for the burglary, and then the 20 years was for the rape that occurred. And so now he's eligible for parole every 2 years because it was a sexual assault crime. I do go back to Raleigh. I now live in Seattle, Washington, or a little suburb outside of Seattle. And I've lived here for 30 years. I left North Carolina because he was out of custody at the time. And I moved as far away from there as I could, which was never my goal. I wanted to go to law school and be a lawyer in North Carolina. Anyway, but through this process, to address your question further, yes, the topic of has he done enough time, you know, is 30 years enough for what the crime he committed? That should never fall on a victim's responsibility to make that call. He was given a life sentence, and I was at the sentencing hearing, and at that hearing, the judge's order or his intent was that Mr. Jones spent his natural life in custody. However, things change over 30 years, obviously, as everyone knows. I'm now looking at the possibility of him being released on parole. And I know that in my heart of hearts that will be a very difficult day for me. However, what is important to me when he is, or if he is released, that he be given as many tools to be successful on the outside as he possibly can. I can never agree to just open the door and let him be free. There are so many triggers for him to commit other crimes that if he is to ever be released, I want him to very much have a probation officer to kind of supervise him with restrictions on things that he can and can't do. Someone who is familiar with his crime, familiar with the triggers that trigger him in committing other crimes in terms of hurting other people. I want him very much to have that support should he ever be released. And that being said, I can never agree to have him just walk out of the prison doors. And when I do go back to speak to the parole commission this January, I will be mentioning those items as well. I hope that answered your question.
Thank you. I really appreciate it. Thanks.
Anyone else?
I'll jump right in. This is Kerwin Pittman. Thank you, Holly, for sharing your story. I know it wasn't easy. And so hearing the story, it makes me think of on DAC's end, and kind of have a question for DAC. Kind of what is in the works to create a container to sustain these type of dialogues, if anything, but also how can TREC be more supportive if it is something currently in the works to sustain these dialogues?
Yes, we are currently drafting policy. I am using, we have a guide of 20 essential practices that I am creating policy around for victim offender dialogues in correctional settings. And I'm also looking at about 6 or 7 other states' policies as well. And so when we get it approved and ready to go, and we think we're ready, then I believe there is a resolution that's being worked on to help us with the outreach portion to make sure every victim across the state will know and have access to this program.
And just curious, will the rollout be specifically for minimum custody, or will it be for all custody levels?
All custody. Because we don't want to restrict it. It wouldn't be a program if we just had to restrict it. So we'll review all victim inquiries carefully and then make a determination whether or not to go forward. And if we do go forward, then we will be contacting or having somebody at the facility contact and talk to the offender and go from there. But the offender will, it won't hurt if he declines. I mean, in no way hurt any parole chances or anything like that if he declines to, or if anyone declines to participate.
And I'm sorry, y'all, one more follow-up question. And I may be getting into the weeds. And I guess I was just thinking, if the victim is deceased, will family members have an opportunity to engage in this process?
Yes, because by statute, victims are considered, family members are considered victims of a deceased victim by statute. So absolutely.
No, those are exactly the kind of questions we wanted to be able to get out on the table. So thank you, Kerwin. And I don't see other hands, so please just jump in if you have a question or a comment. I want to say first to Holly, thank you for being willing to be with us so early in the morning in your time. But also I want to let everyone know you had previously presented to one of TREC committees, and it was just so moving and so powerful that we felt like the entire committee needed, the entire TREC task force needed to hear from you directly. And so thank you for being with us again and for your incredible courage. And I also, of course, want to thank Kim Banco and Val Hansen and John Powell for getting through the technical stuff and being with us. And please know, like, we are continually open to hearing, what TREC can do to be helpful. But I think that with that, unless there's other comments, that it's time for me to turn this over to Secretary Buffalo.
Okay, thank you, Justice Earls, and thank you to our presenters, and I appreciate your leadership and your courage as well, Holly, and thank you for being with us this morning. We're at
for
that
having
point.
me.
Thank you. We're at that point in our agenda for our committee updates where our TREC committees have been doing some great work and facilitating and working towards our TREC recommendations. So we'll hear from the chairs of those respective committees or a representative from that committee, and we'll start with the executive committee.
Good morning, everybody. I'm Kara Bridges. I am staff to the executive committee. Billy Garton is our chair, and he was on earlier, but he had to pop off for another meeting. So I'll give the update for the exec committee today. The executive committee has been quite busy in the last quarter. At their August meeting, the committee heard from Kelly Crosby, who is the director of the Department of Health and Human Services Division of Mental Health, Developmental Disabilities, and Substance Use Services. She oversees, and her team oversees, the 988 Suicide and Crisis Lifeline. When she gave her update, they had just recently celebrated that 1-year anniversary of that statewide launch. And so she came to the executive committee to talk about what work DHHS has been doing in that space, and in particular ways that TREC could support the program and help increase awareness statewide. And so one of the things that came out of that was that we created a subcommittee within the executive committee to explore this option, ways that we could support 988 in general. And one of the first actions that was taken was Director Crosby and her team were invited to present to the TREC Law Enforcement Advisory Group. And so they came in August to meet with those folks to learn how law enforcement and 988 could partner together to help with response efforts and things like that for folks who were experiencing mental crises. So that was a great meeting. There was good discussion around potential for collaboration. So throughout the next quarter, we'll continue to explore that in ways that TREC in general can support that 988 program. In September, the committee heard from Dr. Tate, who is the executive director of the North Carolina Office of Violence Prevention. I think everybody at TREC is quite familiar with OVP. There was a resolution that you all passed in support of creating that office. And that was done so. So Dr. Tate is on board. He joined the committee to sort of talk about the work he was doing and his background and his efforts that will be happening throughout the next year or so. And so that was a good meeting as well. And the committee got the chance to talk with him and ask questions and sort of talk about his plan and vision for OVP. And then in our October meeting, which was just a couple of weeks ago, the executive committee took a deep dive on the restorative justice work that you heard about just now. And so the committee heard from Kim Banco, director of the Department of Adult Corrections Victim Services. She gave an overview or a more in-depth overview of the policy research she's been doing in preparation for developing the DAC policy around victor offender dialogues. And then we also heard from Emily Coward. Emily is a fellow TREC member who you've also heard from today. And Emily has been working on a draft resolution to ultimately present to the full TREC committee around expressing support for the work that DAC is doing in this victim offender dialogue space. And so we are still working on ironing out the details of that resolution. I think we're very close to being able to share that with the entire committee. But if it's okay with you, Mr. Secretary, I'd like to give Emily the chance to just give a quick overview of what she's been working on in regards to that resolution, if she would like to. I don't want to put her on the spot. And I think she had mic issues earlier. So Emily, I don't know if you're able to speak. Okay, I'm gonna take that as a no, but Emily, interrupt me if you are able to come on. So Emily, a lot of credit to Emily. She's been working very closely with the executive committee to develop that language. And hopefully we'll have that out to you all for review and ultimately to get your feedback and hopefully your consideration on a vote in favor of that resolution at a future meeting. And Mr. Secretary, that is all I have for the executive committee.
Okay, thank you, ma'am. We allotted like 10 minutes for each committee. Anybody have any questions since we have about a minute left? Okay, great. We'll go to the Judicial Committee.
Good morning, everyone. Nisha Williams, the co-chair of the Judicial Committee. I have a short update to share with you all. I wanted to lift up two particular endeavors that we worked on this past quarter. The first that we want to highlight is what we're planning on currently doing. It was just mentioned by Kara, around Emily. Emily Coward is also on the Judicial Committee, and she is assisting the Judicial Committee on working on a one-pager for court actors involved in the master jury list formation process. So that way we can highlight the TREC recommendations aimed at ensuring jury list inclusivity. We'll also be drafting an introductory letter that will accompany that handout that will also explain why this work is important. And in particular, it will also highlight the jurisdictions that are experimenting with these practices. We weren't able to have that document ready for today's quarterly meeting, but please look out for that document that will be circulating within the next few months. And lastly, we want to highlight the reentry simulation. I know many of you have heard myself as well as our co-chairs, Secretary Buffalo and Justice Earls, lift up folks attending the reentry simulation. We did have 125 folks register for this event and 80 people attended. We also had 2 media outlets cover the event. We had WRAL and CBS. After I conclude my comments, I will also put in the chat the link to both of those news reports. And we did also do a survey. And during the survey, we received over 30 responses, and everyone that responded to the survey around the event were very pleased with what they learned. The Judicial Committee is going to continue to partner with the Department of Adult Corrections to host simulation events next year in both the western part of the state as well as the eastern part of the state. The reentry simulation that we hosted this year was at NCCU. And we want to also give a huge shout out to our sponsors, which included NCCU School of Law, Department of Adult Corrections, Conservatives for Criminal Justice Reform, as well as the Attorney General's Office, and especially thank our facilitator, AUSA Rob Lang. It was a wonderful event, and we had many TREC folks there, as well as staff from DPS. And we are very thankful for the support of TREC for this event and are excited about the energy around supporting reentry councils throughout the state. And at this point, I'll take any questions that anyone might have.
Can I just ask, I think, was it part of the Judicial Committee's goal on the reentry simulations to also explore the possibility, and this is something that I raised with the Legislative Committee, so that's why I'm mentioning it again, to that we might have something in Raleigh for legislators and legislative staff?
That is still a goal that we're actively working on. We do know that we're actively partnering with the Department of Adult Corrections. And so as we're partnering with them on how to lay that out, is still part of one of our agenda items when it comes to the reentry simulation. But what we do know is that coordinating that was quite difficult this year, which is why we kind of recalibrated and decided to host it for community folks. But we will be still looking at that for our 2024 calendar.
Okay, thank you. Emily did respond. She's still having some technical difficulties, but Kara's summary covered where they stand on the resolution. She's hoping to get that back in front of the full task force very soon. So thank you, Emily, for the update in the chat. And now we'll move to Legislative Committee.
Thank you, Secretary Buffalo. My name is Mushtaba Mohammed, North Carolina Senate, District 38. I want to thank my fellow colleagues on the committee, Representative Morey and Sheriff Burkhead from Durham, and of course, Chief Jennings. Thank you all for being here. You might have heard last time, I know, along with fines and fees, we've had a discussion about really revamping a lot of the issues that are still needed that the task force recommended related to fines and fees. So we had a collaborative approach a couple of months back related to driver's license restorations. Well, last month we had a conversation about juvenile life without parole. This also was a bipartisan bill that was pushed by the General Assembly. Unfortunately, it hasn't gotten much traction. So again, the Legislative Committee is trying to revive a lot of the recommendations from TREC. So I think that's why it's so important to go back and look at the recommendations from TREC. So I wanted to take a moment to look at recommendation number 69, where TREC recommended replacing juvenile life without parole with juvenile life with parole sentences and parole eligibility after 25 years for first-degree murder convictions and parole eligibility after 15 years for people convicted of other offenses and sentenced to more than 15 years. This legislation that TREC recommended would have merely allowed criminal defendants to be eligible for a parole hearing after either 15 to 25 years. It would not mandate release. So having had bipartisan pieces of legislation that haven't had traction, our legislative committee has again continued to bring justice-involved individual policymakers, both Republicans and Democrats, to have these discussions. So on October 2nd, we had almost 55 attendees on WebEx and over almost 30 folks that joined us on YouTube to talk about juvenile life without parole and the reforms for that. It was moderated by our very own Representative Marsha Morey. We had Chaplain Jason Hackett, Jason Hackett, who joined us as faith-based representation. We had Representative John Hardister, who's a Republican for the North Carolina State House. We had a Republican state senator from out of state, North Dakota, where they have been able to accomplish this, Diane Larson. We had our own Jeff Neiman, District Attorney from Chatham and Orange. We had Democrat Representative Charles Smith. We had Reverend Tim Webster and Anthony Willis, who was granted clemency from Governor Cooper. So again, we're just trying to keep these issues at the forefront, trying to keep the conversation going with a lot of the recommendations that TREC made. We're gonna continue to have conversations related to gun violence prevention, some other topics. We also wanna potentially look at ways to reach out to our lawmakers, working with the Conference of District Attorneys, working with the Sheriff's Association, the Police Chiefs Association, AOC, and justice-involved individuals to continue to further a lot of the goals and aims of TREC and the recommendations. So thank you, Mr. Secretary.
Thank you, Senator. Anyone have any questions of the Legislative Committee? Thank you. We'll move along to the local policy.
Well, thank you, Mr. Secretary. My name is Mike Hawkins. I'm chair of the Local Policy Committee and I'd like to bring you up to speed on the things that we are working on and beginning by reminding everyone of the overall goal of what we're trying to accomplish with local. And it's the same as it's always been ever since the beginning of TREC, is that local sees its role as in large measure to educate, to bring the message out, to bring people, especially on the local level, in rural areas of the state and areas far away from Raleigh. Sometimes the recommendations itself, we have to bring people from an area of low information to higher information, and then we can get them to work with us and work with other agencies in terms of implementation of particular recommendations. So that's a big focus of what we do. We do it this year. We've got 4 different areas that we're working on, and I'll briefly mention one thing that's going on in each area. I won't try to mention everything. First area is grassroots outreach. And by that, we mean we are trying to engage with these agencies and stakeholders around the state that work in this space to see how we might be able to help them, how they might be able to work together across geographic areas and across functional areas. Our first step in that is actually identifying who these people are and developing a master list of these organizations and these stakeholders. That doesn't exist now on a statewide level. And we have begun that process. We're going to be doing it regionally. We're beginning with the Triangle area where we're surveying. We're sending information about TREC out, surveying agencies that we know of to try and enlist their help to let us know about agencies that we may not know of. And we will take that work, and then when we're done with the Triangle area, expand it across the state. And that's ongoing. And that is and I would say the other thing I would say about that, that's a huge project. It's going to be hard to do. It's going to take time to do, but it's also a very valuable project. Once we have that master list, and it will be a living document, and it will change. But once we have that, that will be such a resource for not just TREC, but other agencies as well, other entities as well. So we're excited about that. So that's grassroots. The second area that we're working in is law enforcement outreach. And we have done that, again, since the beginning of TREC, the traditional way. And we have worked with the Sheriff's Association, with the Chiefs Association. We have done, used to be monthly, now quarterly meetings with the Law Enforcement Advisory Group, which is extraordinarily helpful, a group of law enforcement leaders from across the state. We convene and typically have a topic that we talk about. They help us look at it from their perspective, give us suggestions, and they've done a number of things, or they've provided a number of ideas that we've then used in our work, including something I'm going to mention here in just a second. So but the other thing I'll mention, because it was mentioned with judicial and with legislative, is this concept of bringing people together, maybe having seminars or webinars or an event. We have talked about that in very early stages with law enforcement, that law enforcement could be a good venue to have the type of event, kind of like what Senator Muhammad just talked about, or what Nisha Williams just talked about. So that's something, and now that I've said it, vocally, maybe I shouldn't have said that. We have to do it now because I said it vocally, but that is something that we're looking at and doing more than one. If we can do one, we'll do more than one. Third area is local area outreach. Local leader outreach, again, the traditional area, which we have done and continuing to do, is working with the Association of County Commissioners and the League of Municipalities. Those are the two logical organizations or entities. But we're also, we have a presentation, we've developed a presentation that we can make to local organizations, local entities. And I say that's on my mind because we just did that last week with a group of county and municipal elected leaders in Henderson County, which is in Western North Carolina in the mountains. Henderson County is doing several things that are really interesting, that are TREC recommendation kind of things, areas of diversion and other areas. So we went, Mayor Blakely in particular, Preston Blakely, who is a member of our group, went and made a presentation to them about TREC and actually use the opportunity to make suggestions to these leaders about ways in which they can work collaboratively within their county to do other recommendations beyond what they're already trying to do. And the final thing that I would mention, the final area, which comes from a meeting of that law enforcement advisory group last year, where the topic was talking about culture within departments and how do you correlate, or how do you translate policy into culture. And so we've put together a group. We're working on that, working with actually Duke University, the Wilson Center at Duke University, with the idea being to develop, first of all, a survey so that interested law enforcement agencies might be able to survey their departments, get a sense of what their departments think about policy, changes that they might make, what's good about it, what's bad about it, but mostly to understand the policy of their, or excuse me, the culture of their departments and how it might relate to their stated policies. And we're really excited about that. So 4 areas that we're working on, we continue to work on. The last thing I should have said at the beginning is I do want to mention the members of the committee that we're on, the task force. And they're Deborah Dix Maxwell, Preston Blakely, I mentioned Preston, Tracy Campbell, Kim Scott, Josh Stein, Ricky Hurtado, and also Kerwin Pitwin, who wasn't originally a member of our group, but we've kind of stolen him, and he's now working with us. And then the staff support is Brandy, of course, Brandy McCoy, Ashby Ray, Sherry Hunter, Natalia Patella, and Jasmine McGee. And they all do a ton of work, and we're excited about what we're doing. And I will hand it back to you, Secretary Buffalo, for any questions.
Thank you, sir. Any questions for Local Policy Committee? Okay. Thank you to our committee chairs and representatives for your report today. And we'll transition to any new businesses if I don't see any hands or questions in regards to our committee reports. Okay. Any new business for TREC at this time? Okay. Not necessarily new business, but just an announcement. DPS did post the Deputy Director for the Office of Violence Prevention. It's on our website. It's out there. It will close, I believe, November the 3rd. So if you know of someone that's interested in that position, please let us know. Thank you for the hard work from our DPS staff and DHHS staff in making that position happen. So just wanted to put out there. I think I saw in the chat where Assistant Secretary Bryant had posted the link to it and possibly sent everyone an email in regards to that posting. So thank you. Pending no new business, I'll turn it over to you, Justice Earls, for our public comment section.
Secretary Buffalo.
Yes, ma'am.
I'm wanting to interrupt to say that we might want to, at the next meeting, or figure out at some point in some of our committee meetings, get somebody that can give us a 5 or 10 minute WebEx brush up for our technology efficiency, since we often, it's not necessarily the main platform that a lot of us use, so that we are sort of ready for these meetings and can operate efficiently. Just a thought.
Okay, thank you, ma'am. Definitely take that back for our next meeting here on the WebEx platform. Thank you for that suggestion. Justice Earls, I'll yield to you, ma'am.
Yes, great. Well, the good news is our next meeting will be in person. So, but yeah, I'm looking forward to that very much in January. But at this point, we are at the part of our meetings where we invite members of the public to present to us, and there's a sign-up process. And as everyone knows, we are faithful to the 2-minute limit for comments, but it's really valuable to us to hear from members of the public about what's important to them about our work. And so we have one person who has signed up. And so I think at this point we can hear from Katrina Hayes. I think you'll be promoted to panelist, and we'll have 2 minutes to hear from you.
Okay, thank you so much. Good morning. I recently heard New York Attorney General Letitia James say, "When you have built an empire on falsehoods, the truth is your only enemy." The title of my comment is "The Clamor of Injustice, the Well-Known Secret, the Pink Elephant." I notice Attorney General Das Stein is no longer on the call. My comments are directed at him. This is my call, my continual call for justice to be served regarding the deprivations of numerous rights from a mock special education hearing engineered by Cumberland County Schools in Fayetteville, North Carolina. My son, Tristan Olive, was one of the students in that case. I am aware of the stealthy and overt retaliatory actions by the state to silence and frustrate us and dodge responsibility. I will not be intimidated. Thank you for your time.
Right. Thank you for your comments. And just generally, I'll say we continue to always also welcome written comments that can be submitted through our website. And so that's also another way to get information to the task force. So Secretary Buffalo, you are still with us. Do you want to I think we're at the meeting wrap up and adjourn portion.
Sure. We are ahead of schedule. So as far as our wrap up is concerned, we have set some tentative dates for our quarterly meetings for 2024. This year has seemed to go by in a flash. Director McCoy and her team will push out those dates. I believe they're on possibly your agenda. I'm not sure. If not, you will receive those. So our next planning meeting is scheduled to be in person on Wednesday, January the 24th at 10 a.m. That location is to be determined, but we're looking at an in-person meeting. Following that, it'll be on Friday, February 23rd, Friday, April 26th, Friday, August 2nd, and final meeting for 24 will be Friday, December 13th. There may be some additional meetings added in August and December to be determined, but Director McCoy will definitely send out those 24 meeting dates. And that's the wrap up. Did I miss anything, team?
No, sir.
Okay, well, a great meeting. We'll give you back about 28 minutes of your time today. Thank everyone for your attentiveness and leadership in TREC. And please have a safe and happy weekend. And that will conclude the meeting. Thank you. Bye-bye.